Hi everybody, this is Jeff Fowler with the Apartment Owners Association. We've been around for over 40 years and we're one of the largest individually organized groups of apartment owners here in the state of California. It is great to have you with us, and I'm glad that you're with us because it's so easy to get in a lawsuit because you don't understand resident manager law. So we're here to help you avoid the landmines today. And it's not legal advice, but we're just going to be sharing the updates for the 2024 laws and wages and all of that. So before we get into it, AOA, like we said, we've been around for over 40 years. And our goal really is to help you make and or keep more money than ever before. And our goal specifically is that this group of apartment owners would be the most successful, not only in the state, but in the country. So we're constantly having seminars and putting articles in the magazine and updating forums and doing different things to help you be as profitable as you can and making that as easy as possible. And we do have tenant screening that we've been doing in-house for decades, and one of the unique features is that our eviction report does have two different companies that we use, so you get actually two different reports with that. And then also just want to say, I've mentioned it here and there, but just the importance of running a single county criminal report. In California now, there's about half of the counties have redacted the date of birth from the records for instant searches. And so what that means is, by law, any of the different tenant screening companies that are out there cannot show you that information. However, if you run a single county criminal report, that information is available. And so I want to highly suggest doing a single county criminal report if it's legal in your county, and you'll know who you are if it's not legal. But anyway, just one little tidbit on that. And man, we've had a great time the last 2 weeks. We've been in lots of different cities just giving tax tips and bringing in experts and doing that. So you may have missed that in January, and January 31st is the deadline for issuing those 1099 NECs and the 1096 to the IRS that you have to do for. But anyway, besides that deadline, we at least can look forward to next month, and we will have on February 7th, eviction attorney Franco Simone in San Diego. And there will also be, with that in-person seminar, there will also be a Meet the Candidates event right paired with that. So that'll be a double header, and that will only be in person. And then we also have eviction attorneys speaking in Buena Park, in Long Beach, and Sherman Oaks, and they're going to be covering understanding the eviction process, and that's next month, February 13th, 15th, 20th, and just so that. And then also for Northern California, absolutely not forgotten, we're having the Bay Area Landlording Power Conference, and there'll be 6 different speakers there. So with seats, tickets are going quickly, so definitely reserve a spot because seating is limited on that. And then, of course, March 20th, we have the AOA $1 Million Trade Show. There we'll have over 20 different seminars for you in just one day. And there'll probably be about 150 different vendors that are present there. And that'll be a great time to sharpen the axe, just as right now is a great time to sharpen the axe. And so if you're watching on AOAUSA.com, there's that blue help button at the bottom right side. You can type in questions there and they'll get those over to us. And we want to welcome everybody watching on Facebook, watching on YouTube. Great to have you with us, watching even on, Rumble. So yeah, we're all over the place, coming to you live right now. And so our speaker today, he has over 30 years of experience, obviously an attorney. He drafts resident manager agreements for people, and I think this is very important, that you have this customized to your specific situation. He defends owners and management companies. He is the chair of the litigation department at Parker Milliken, and he writes articles for the AOA magazine from time to time, and especially the one article that you'll want to check out is the resident manager law article that we just posted in January. And if you are on AOAUSA.com, in that little search area there, you can type in resident manager, and that article will pop up right there for you, and you'll be able to read that article online if you'd like. All right, so yes, so we'll give it away to our speaker today. It's Gary Ganchrow. Thank you, Gary.
Thank you, Jeff. And before I get going, I just want to say thank you to AOA and to Jeff and everyone else here. This is, I think, a very big service that they do in terms of having me come and speak, in terms of all of the other speakers and webinars and live presentations they do. There's a lot of information out there that you need to have, and this is, you do an amazing job presenting it. Let me tell you what I hope to cover here today. I'm going to assume that if you're watching this, that you're probably somewhat familiar with the basic payment structures for on-site managers. But I definitely hope to go through them anyway, at either a little bit faster or a little bit slower. I hope to cover and share with you some of the litigation and lawsuits that I am involved with in terms of defending typically owners or property management companies who are being sued by on-site managers. And throughout all of this, I hope to discuss with you best practices and how to avoid the lawsuits and avoid being the person who's being sued. So we're going to talk about all that. Let me just start off by saying this stuff is incredibly complicated. The payment structures and how do you pay and rent credit and check exchange, all of that, and the numbers change every year. It is complicated, and I say that from the perspective of someone who considers myself and does employment law. I'm an employment lawyer, I do employment litigation, and even for me, this is complicated. And there's a lot of litigation that I see that comes from resident managers making claims, and resident managers filing claims with the labor commissioner, what used to be known as the labor commissioner, and actual lawsuits in court. And my last kind of caveat and introduction is a lot of what I'm going to tell you here today doesn't make any sense. And hopefully it won't make sense to you, not because I'm doing a poor job of explaining it. That could be too. But hopefully it doesn't, but it won't make sense because it just doesn't make sense, because the laws don't make sense, because a lot of times when we're dealing with employment laws and we're interposing them on resident managers, it's like a square peg in a round hole, and it just doesn't work. And I'm going to say things, and I know that, you know, wherever you're watching it, in whatever form, you're going to be making faces and looking at me like I'm crazy, because that's not the way it can work in the real world. And I concede that, up front, that a lot of this doesn't. And I think that's one of the reasons we see a lot of lawsuits, is because a lot of this stuff doesn't make sense, and it's very hard to follow, and it's very hard to comply. The other reason we see a lot of lawsuits is because there are, and you got to know this if you don't already know it, there are lawyers on the plaintiff side who specialize in just filing resident manager lawsuits. So just for fun, I went online before I came here and I plugged in resident managers and lawsuits. I don't remember exactly what my search was. And I pulled up, I'm not going to give you the names of the people advertising, but this law office says they focus on representing resident managers of apartment complexes throughout California to recover improperly held wages. So that was one that pulled up. Another one that pulled up says, if you are a residential apartment manager in California and believe you are not being paid the compensable wages you are owed, contact this lawyer. So there are lawyers that are prowling for on-site managers. You got to know that, and obviously that's part of the reason we're seeing a lot of litigation, and there's other reasons we'll talk about. But let's start with going through kind of the basic payment structure when you're paying an on-site manager. And let me kind of lay down a couple of what should be fairly obvious, but I find often isn't that obvious. Number one, a resident, if you have an on-site person, an on-site, we'll call them an on-site manager, but as we'll discuss, the term doesn't really, what you call them doesn't matter all that much. If you have an on-site person that is performing work for you, they are an employee, right? They're a W-2 employee, they're not a 1099. It doesn't matter if they're doing a lot, it doesn't matter if they're doing a little. It doesn't matter if they are just meeting vendors every once in a while or they're keeping an eye on the place. If you're compensating them for that and they are working in expectation of getting paid for it, they're an employee. And I know everyone wants to, I shouldn't say everyone, but a lot of people want to circumvent that. And it doesn't work. They're an employee. So that's kind of premise number one. As I said, it doesn't matter how much or little they're doing, and I guess it's important for you to know there is a lot of elasticity in what the on-site person can be asked to do. There's no rule as to they have to work a certain number of hours, they can't work a minimum number of hours, they can't work more than a certain number of hours. The responsibilities can vary, and the language in the state regulation that requires an on-site person uses the term a manager, janitor, housekeeper, or other responsible person shall reside upon the premises. So responsible person, again, there's no ground rules in terms of how much or little you can ask them to do. Okay, premise number two is because they're employees, you must pay your employees. Employees must be paid. That's the rule in California. And so as we go through these various structures, keep in mind, no matter what we're talking about, you are paying them. I'll be clearer about that in a minute. So let's talk about the two different ways that you can pay an on-site person. Let's take the first way, what I consider the simpler way to kind of explain, is what we call a check exchange, right? A check exchange is I think pretty simple and pretty straightforward. Check exchange is like any employee, they get paid on the books, W-2, you write them a check or direct deposit, however you do it, they need to get paid at least twice a month. That's the rule in California. And whatever their hours are, and they are hourly non-exempt employees. Non-exempt is another fancier word in essence for saying they're hourly employees. They have to get paid for all of their time, and they have to record their time. And you take the time, the hours they work, you pay them out of pocket for their time. And that's the first check, and then you're giving them a check. And then the check exchange part of it is they are paying you, we'll call it rent, to live in your building, in the unit. And these are like two different transactions as if you're dealing with two different people. And that's a check exchange. What you do need to know, though, is if someone has to live on site, if you have an employee and you are requiring them to live on site, as you are with an on-site manager, especially if your building requires one, let's say it's 16 or more units, then there is a cap on how much rent you can charge that person. And if you are doing a check exchange, then that cap is going to be 2/3 of whatever the fair market rental value is of that unit. So for example, if you have an apartment unit that is worth that on the rental market is worth $3,000 a month, and you have your resident manager in there, and you are using a check exchange, the most you can charge that manager for rent is $2,000. It's that 2/3 of the $3,000. So that's the check exchange, pretty straightforward. A little bit more difficult to explain now is the other way of paying an on-site manager, and that is with a rent credit. So how does a rent credit work? So again, our starting point with a rent credit is, again, you're capped on how much you can charge them for that, to live in that apartment unit. The cap, though, is a little bit different than it is with a check exchange. With a check exchange, I said it's 2/3 of the fair market rental value. With a rent credit, if you're using a rent credit to pay them, so then the cap on how much rent you can charge is going to be, and this is where you might want to get your pens and pencils, going to be the lower of 2/3 of the ordinary rental value of the unit, or some number that comes out of a wage order that is published every year with new numbers. That's in the article I write every year, and that's where you can pick up the numbers if you don't know where else to find it. So for this year, the numbers for an individual on-site manager, the cap on how much you can charge is $903.60. If you're dealing with a couple, meaning that you're employing a couple as the resident managers, so that number is $1,336.65. That's your starting point in terms of how much you can charge them to live in the apartment. And this is important because now we get to the rent credit part. So what's a rent credit? So a rent credit is you're going to take the amount that you could charge them. Again, it's either going to be that 2/3 number or one of these, let's say 900,360. Let's take an individual just to make it simple. So it's either going to be the 2/3 ordinary rental value, the lower of 2/3 the ordinary rental value, or the $903.60. And then from that number, instead of paying the on-site manager out of pocket for their work, you're going to give them a discount off of that rent amount. What is important to recognize here is when you discount your $3,000 apartment and you're only allowed to charge $903.60 because you're using a rent credit to pay the manager, that is not payment. That's just a discount that the law says you have you get the benefit of giving your on-site person for the privilege of employing him. So our starting point for rent, when you start the rent credit, is that $903.60 number, or the 2/3 number if that's what it is. So from that $903, you will now pay, again, either using some or all of it to pay the manager for his hours. And this is where I wish there was a live audience where I'd be able to tell whether or not I've already completely lost you and confused you. I'm going to assume I haven't, so I'm going to go on. I want to change some of the terminology that I hear from clients all the time and hopefully change the way you think about all this. Because a lot of times I hear clients who are using a rent credit to pay say, well, they're not paying the resident manager. And what they mean by that, of course, is they're not paying out of pocket, which I understand. But don't think of it like that. You are paying them. You have to pay them. It's the law. You have to pay them for their time. You're paying them. You're just paying them using a rent offset from the $903 number. The other thing I hear people say when they're using a rent credit to pay is they're giving a free apartment. And again, I understand why you use that terminology, but it's really not a free apartment. The manager is paying something for that apartment. Again, they're just not paying out of pocket, but they are paying in the form of not getting the wages that they would have gotten if you weren't using the rent credit. So hopefully that is somewhat clear. So let's just kind of give an example. Let's take our $3,000 apartment. If you're using a rent credit, right, 2/3 of $3,000, even I can do that math and I'm a lawyer, is $2,000. And so the $903.60 number is obviously the lower of the two. It's lower than $2,000. So that is your cap. Now, if you're paying with a rent credit, let's just assume for this discussion that the on-site manager is working, I don't know how many hours this works out to, but he's owed $1,000 every month, or approximately $1,000. That's how much he's working per month. So you're going to take this $900 or $903 rent credit, apply that towards his wages, and now you're going to owe the difference between the $903 and the $1,000, and you're going to have to pay them out of pocket. You cannot use a rent credit of more than that cap. If that cap is $903.60, that's your cap, and you cannot rent credit or pay or use more discounted rent to pay than that $903.60. And this is where a lot of people get confused and a lot of people run into trouble. So again, not being able to see anyone's face, I'm going to assume that was all very clear. Sticking with the same example, if you're going to use a check exchange, again, it's obviously much simpler. A check exchange now, our cap is the 2/3 of the fair market rental value. We're going to assume $3,000 apartment, so your 2/3 is $2,000. So you can charge the on-site manager up to $2,000 in rent to live there. And he gets paid, again, out of pocket, because we're talking about a check exchange, he gets paid whatever he earns. Maybe it's $15 a month, maybe it's $1,000 a month, maybe it's $4,000 a month. It doesn't matter, because you're going to pay him separately, but the most you can charge him in rent is that $2,000, that 2/3 number. Doesn't mean you have to charge the full 2/3. Often people don't, but you can. So One other thing I should point out is if you want to use a rent credit as a way of paying, you need a written contract with the on-site manager that expressly says that he's going to be paid in the form of a rent credit. If you don't have that written contract, you may have the best of intentions in terms of paying. You may be paying very handsomely. You may be paying a lot of money, but the law will not give you credit for paying through that rent credit. So whatever you're paying in the form of that rent credit, the law says you didn't pay. And again, that's an easy way if you're not familiar or you're never paid attention to these rules. That's an easy way to get in trouble. And it's kind of low-hanging fruit, quite frankly, for plaintiffs' lawyers if they see a rent credit being used with no written agreement. Why would you use a check, or I guess when, in what circumstances would you use a check exchange? In what circumstances would you use a rent credit? Let me answer the first question first. When would you use a check exchange? Typically, there may be a lot of reasons you want to use a check exchange, but typically, if you have an apartment with a significant value, you want to use a check exchange because from a pure financial standpoint, you're going to come out ahead. Why? Because let's take our $3,000 apartment example. If you've got an apartment worth $3,000 and you use the check exchange method, as we just said, you can charge up to $2,000 in rent. If you use a rent credit, then you're going to be capped at that $903 number. Remember, it's a different cap. And so you're eating the difference between that $903 and that $2,000. There's a big window in there that you're eating in the form of lost rent. There are some tax differences, quite frankly, that I'm not going to get into that make up a little bit of that discrepancy. But obviously that's a big loss. So the higher the value of the apartment, I think the more likely you would want to use a rent credit. I'm sorry, I said that wrong, a check exchange. Why would you use a rent credit? People, in my experience, want to use a rent credit just because they don't want to come out of pocket and write a check or a direct deposit every month. They just prefer, I guess, from a cash flow perspective, to not have to come out of pocket and do that kind of exchange where you're offsetting the rent, the wages and the rent. Other times I have found people want to use a rent credit because they have an on-site manager who is on some kind of program where they cannot show more than a certain amount of income, or they lose the benefit of that program. And so with respect to some of those programs, if you're using a rent credit, that income, that phantom income in the form of rent credit, doesn't count against the income that person's owning, so it doesn't push them over the cap, whereas a check exchange is just a regular payment and obviously would be considered income to them for the purposes of whatever program they're on. I'm being vague intentionally because it really depends on what the program is, and you really have to look at each one. SSI works different than Medi-Cal, so you kind of have to look at the program and what their criteria are in terms of what they consider income to determine whether or not using a rent credit helps in that respect. But let me talk a little bit about contracts. Jeff mentioned in his introduction that I do resident manager contracts. I, in fact, do a lot of resident manager contracts. So let's talk about what the purpose of a contract is in this context, of course. So number one, as I mentioned a minute ago, if you're using a rent credit to pay, you need a written contract because otherwise you're not getting credit for the rent credit. But beyond that, even if you're not using a rent credit, I think the contract is very important in terms of laying out expectations, both your own and the expectations for the on-site manager. How many hours will the on-site manager be working? What will happen when their employment is terminated? What will happen with them? What will happen with their apartment? What are their job duties? Will they be working overtime? Are they expected to not work overtime? Are you going to put a cap, so to speak, on how many hours they should be working? Can they work overtime but only with authorization? Things like that and a million other things, just in terms of setting the expectations, I find is useful. But even more, I think, importantly for my purposes as a lawyer and representing a client, the contract is there for your protection. When I do a contract, and many of the other contracts I've seen by people who do them in the industry, we build in, I know I do, a lot of language in the contract that is language that, number one, is designed to protect you from ever getting sued, because it, the idea as a plaintiff's lawyer looking at it is going to be discouraged from filing a suit because you have a good contract. Number two is I put in a lot of language that if you do things right, you can then point to in the contract as saying to the resident manager, no, you weren't, you shouldn't have done that. You weren't allowed to do that. You breached the contract by doing that. And a lot of, call it CYA type stuff for your protection. I find sometimes I'll draft contracts and clients won't understand the purpose of all that language, and everything in there has a purpose, and they'll pull it out. I've had experiences where I'll send the contract, I don't see the signed version until there's a problem many months down, and I'll say, well, please send me the signed version. I get the contract back, and language has been pulled out and changed. You're the client, it's within your right to do that, but it's not usually a smart thing to do it, or at least not without discussing it with me first, because there's usually a reason that language is in there. Let me digress a little bit. I, in addition to the contract work, I defend a lot of resident manager lawsuits, claims and lawsuits. By my unofficial count, I think right now I'm handling about 6 or 7 ongoing lawsuits that are brought by resident managers. And these are all different types. Some of these are individual lawsuits brought by the resident manager, just by him or herself. I'm handling some that are now class actions, where they're trying to sue on behalf of everyone else similarly situated, whatever that means exactly for a resident manager. I'm handling, a lot of them are what are called PAGA lawsuits, Private Attorney General Act lawsuits, which are kind of like class actions, but without all the protections, kind of like class actions on steroid or speed. And so these can become a big deal. And so when I'm writing because I write contracts and because I'm also defending lawsuits, I find that it's a dynamic process, meaning what I see, the claims I see being made in lawsuits, and I hope to talk about that in a few minutes, but the claims I see being made in lawsuits work their way into my contracts because I say, oh, I need to protect against that. And it's kind of live and learn as you go. And, plaintiffs' lawyers are creative people too, and they think of theories. So, my next step is to work that into the contract and how to protect you from those kinds of claims. Just to give you an example, I've started putting language in my contract that allows me to be more aggressive when I am defending lawsuits. If there were ever a lawsuit out of that contract, and I have started filing cross complaints against the resident manager when they file a lawsuit and they say, I worked 53 hours a month, when their contract says they're only supposed to be working 36 hours a month. And they promised they would only work 36 hours a month, and they promised they would seek authorization before they worked more, or they come in and they claim they worked overtime when they promised that they wouldn't work overtime, or they'd get authorization before they worked overtime. Well, guess what? It gets even better, because a lot of them actually give time records, which we'll talk about. But they give time records, and they promise those time records are accurate. And their time records say 36 hours a month, or 35, or whatever the number is. And then they walk into court with their plaintiff's lawyer and say, those weren't really accurate. I was really working 50, 60, 70, you name it. And I've seen some unbelievable claims. I've seen claims where when you added up the hours, they were literally working like 27 hours a day. And I'm not making this up. But I'll work that into the contract. And so now there's a mechanism in the contract to say, well, wait a second. If you really were working those hours that you claim you were working, then you were breaching the contract and possibly giving me fraudulent information too when you gave me your time records. So, in a lawsuit, leverage is everything, and you want to grab the leverage wherever you can. So the contract writing is a dynamic process. When I do contracts, obviously they're individualized, but I'm also learning from the claims that I'm seeing, and that becomes part of the contract writing process. Let me jump a little bit to lawsuits. And Jeff, I have no concept of time, so you'll have to, okay. Let's talk about lawsuits a little bit. So why are there a lot of resident manager lawsuits? I can answer that a lot of different ways, so I'm going to give you 3 of my thoughts on it. Number 1 is because relationships with on-site managers, and especially when they are long-standing relationships, as they often become in my experience, obviously not always, they get very personal. And, and often there's a friendship that forms. And there's intimacy is probably too strong a word, but there's a bond that often forms both between the on-site manager and the owner, especially if it's a mom and pop type owner, but also between the on-site manager and the building they manage. And I've heard, more than one on-site manager describe the building that they've managed for 20, plus years. That's their baby, and that's their identity. So when things go wrong, it's very personal. So I think that's part of it, and that leads to that lends itself to hard feelings, often to seeing a lawyer, and sometimes it just starts as a gripe, and then once the lawyer gets involved, then it takes on a life of its own, as often happens. I think another reason there's a lot of litigation in this area is because, as I said, this stuff is complicated. And because it's complicated, it's often not done correctly. And also because it's complicated, and as I said before, it's often like, a lot of these rules are like fitting a square peg into a round hole. It's very hard in the real world to follow this to the letter of the law. So they are often breaches of the rules, and I've only, given you some of them. But it's very hard to follow, and so, lawyers doing what they do, they look for these breaches and these mistakes, and they capitalize on them. They take advantage of it. And the third reason, and maybe the main reason why I think there's a lot of litigation in this area, and this is true of employment litigation in general, is because often there are attorney's fees that the plaintiff's lawyer can claim if they win. And what I mean by that is the labor code the claims being made are violations of various labor code sections. The labor code has what we call in the legal business fee shifting statutes. Fee shifting means they get them and you don't get them. Meaning the plaintiff, if they win, they can recover their own attorney's fees. You as the poor defendant, if you win, you just have the privilege of paying your own lawyer to win, but you can't recover those fees from the other side. So that's a big incentive for plaintiffs' lawyers to file a lawsuit, because if they recover, they get their fees. And especially in these types of cases where, as I said before, it's so hard to do everything right, there's often going to be some mistake. It may not be a big money mistake, but there's often going to be something, at least technical, that they can hang their hat on to say that they won something, and therefore recover their fees. And that gives them a lot of leverage in the lawsuit. So I think for all those reasons, we see a lot of lawsuits in this space. So how do you protect yourself from the lawsuits? So I think there, in talking in general terms, there's 2 lines of protection. One, which we talked about a little bit, is the contract. Having a good contract is significant protection. It's not the end-all and be-all, but it's a very good start. And even more important than having a contract is following the contract that was laid out and doing it the way that the contract says you're supposed to do it. I tell clients all the time, the contract's only as good as the paper it's written on if you don't then do and follow, the procedures that were laid out in the contract by your very careful and thorough lawyer. So the follow-through is critical, and especially with record keeping. I think the one, if I had to cut this all down to 30 seconds and give you a snippet of what's the single most important thing you can do to protect yourself from lawsuits. And look, lawsuits are always going to happen. Often they're frivolous. But to protect yourself from any lawsuit that might look like it has merit, that one thing would be get the time records, get good time records, and maintain those time records. And again, we'll talk about that a little bit more in a minute, but the record keeping is critical. And so many of the lawsuits I see don't involve good record keeping, or the person hasn't gotten time records, or they know they're supposed to get time records, but the on-site manager is very resistant to giving time records. I know that's a problem, and quite frankly, I understand from their perspective why they would be, given the nature of the job. This is one of those areas where the law just doesn't make a lot of sense. My secretary, when she comes in every day, it's pretty easy for her to clock in and clock out for lunch and clock back in. An on-site manager obviously is on duty, off duty, they're working, and typically they're not. And they get interrupted, and they get calls from tenants, and they show apartments. So I understand why there's a reluctance to maintain time records. But from the employer perspective, you've got to make them do it. And you've got to make them real and legit, and you've got to maintain them, because that's your number one protection. So a while back, remember I started off the presentation by saying you got to know these people are employees. These on-site managers are employees. So what does that mean? So they're hourly employees, and from a legal perspective, that means a number of things. Number one, they need to be paid for all of their hours. Number two, they need to be paid for any overtime they work. And they need to be paid, obviously, at an overtime rate for any overtime they work. What is overtime? So overtime in California is anything more than 40 hours a week, anything more than 8 hours a day, and this is the one I think that sometimes gets lost, anything more than 6 days in a work week. Meaning that if you're a resident manager who works 7 days in a work week, which can happen if they're showing apartments on weekends, so some of that time would be considered overtime. So again, if you don't want to pay overtime, then one of the things we want to do in the contract is address that, and address how you're not going to pay overtime, and make sure that the on-site manager is not working a seventh day in a work week, because otherwise you'll get a surprise overtime bill. They have to be paid at least minimum wage. I would think that's fairly obvious. The minimum wage is going to vary from location to location. In California, as of January 1, that's one change, that it went up to $16 an hour if you're governed by the state minimum wage. If you're in the city of LA, it's until July 1, it'll be $16.78. And a lot of the different localities have their own minimum wage, so that's something you need to be aware of and look out for, because you have to pay the minimum wage. They have to be allowed, because they are employees, because they are non-exempt employees, they have to be allowed to take meal breaks if they work a certain number of hours per day. That means more than 5, if they're working more than 5 hours consecutively, presumably, then they're entitled to a meal break. And one of the things you need to do as the employer is make sure, if they are entitled to meal breaks, not only can they take them, but that they record on their time records when they started their meal break and when they stopped their meal break. Because if you don't, there will be a presumption that they didn't take it. If you don't have those records, there'll be a presumption they didn't take a meal break or couldn't take a meal break, and then you're all of a sudden having to disprove it. So you definitely want to include that on the time records. They have to be allowed to take rest breaks if they work certain periods of time. Again, for on-site, and by the way, almost every lawsuit I'm defending in this area has some kind of claim that the on-site person couldn't take their meal break and they couldn't take their rest break. I think that's in the form plaintiff complaint that they kind of spew out. And it's in almost every employment lawsuit. It's not just on-site managers. It just happens to make less sense for on-site managers because on-site managers make their own schedule, typically. Their work schedule is often not constant. And so it's almost and often they're working from their home. So it's almost nonsensical, in my humble opinion, to say that an on-site manager didn't have an opportunity to take a meal break. But you should still be aware that that requirement exists. And again, if they're working that enough time to qualify them for one, you want to make sure that they record that they've taken it, or record that they didn't and why they didn't, if that's the case. Because on-site managers are hourly employees, and I know that, I can't tell you how many times a day I get people who want to do this, and I know it's simpler, but you don't want to pay them a flat amount every month, because you're basically taking an hourly employee and making them, in effect, salaried, and you're paying them a flat salary every month. And the reason that doesn't work is because typically the hours that they work are not going to be identical every month. They're going to vary from month to month. And if you're paying them the same amount every month, that means by definition, the hourly rate that you're paying them is changing. And it gets very complicated, and it gets very complicated, especially if they're earning overtime, to figure out what the rate of pay is that you're supposed to be paying them on. And I'm probably boring everyone who's listening to this now, because like I said, it gets very technical. But trust me when I tell you, it's not a good idea to pay a flat salary amount if you have an hourly employee. And if they are giving you a timesheet that says they're working the identical amount of hours every pay period, though that's not good either, because that's kind of highly suspect. And then if they ever come back and say those were not my real hours, and golly gee, you and everyone should have known those were not my real hours, because how could I be working the exact number of hours every month given the nature of this job? That claim is going to have some credibility to it. And so if their hours are cookie cutter, it's not ideal. I mean, it may be simpler from a bookkeeping perspective, but it's really not ideal in terms of claims they may bring and trying to defend those time records as being real and legitimate. And I know, because I've had to try to defend them. So what are the claims that I typically see? What are the lawsuit claims? So we've already covered some of them. A lot of claims I see are where the on-site manager will say, I was working, quote unquote, off the clock. What does off the clock mean in this context? I guess it really means that I was working time that was not recorded on my time records, assuming you have time records. Typically the claim is, well, tenants were coming, at all different hours, and I got calls at 11 at night or 2 in the morning, and that's off the clock. It's not on my time record, and pay me for that. So how do you defend against that? I mean, how do you protect yourself against a claim like that? And the answer is, number one, again, contract. Right? You want to make sure contractually that you have buttoned it up so that this on-site person has promised every which way possible that they will give you accurate time records and record every minute of time they worked. You want them to do that because you don't want to have to deal with a lawsuit. But that claim is in almost every lawsuit that I'm handling, is I was really working more time than was recorded. And so you really want to protect that. And the other thing is, and I guess a related claim, is often the on-site manager, and this comes up all the time, will say, I was told how many hours to put on my time records, or I was told I could not put more than a certain number of hours, whatever the agreed on number of hours was that they would work per month. I was told I could not put more hours than that, but I really did work more hours than that. Or another one I get frequently, it's just a variation of the same theme, is I submitted a time sheet and it had more hours, but it was sent back and I was told, no, I can't put that many hours. I have to knock it down and I can only put so many hours. And I will tell you, I think sometimes these claims are complete nonsense and completely manufactured and just untrue. But there have also been occasions where I think it's true, because somewhere along the line, sometimes it's an owner, sometimes it's someone in the chain at a property management company, says to them, don't report those hours, we don't want to pay you for them. Whatever the exact discussion is not clear, but the takeaway from it, at least from the on-site's manager perspective, is, oh, I shouldn't put down those hours. So you really, really want to be careful, and you don't want to lend yourself to any kind of claim like that. You do not want to suggest how many hours they can put down in their time records. You do not want to suggest that they change their time records. You do not want to do anything that will in any way enable someone to claim that their time records have been doctored. If someone is working more hours than you want them to be working, or you think they should be working, you have to address it with them. But not by telling them to change their time records. Pay them for that time, and then address it with them and say, look, we don't want you working those hours. I want you to record all the time you work, but we don't want you working those hours, or we want you to get pre-authorization if you're going to work those hours. And typically we'll put in a contract some number, but again, at least the way I do it, it's not a hard and fast number, because often it's hard to tell exactly how much they have to work. It's more of a rule of thumb. And if their hours are exceeding your expectations in terms of what you believe they should be working, address it with them. Either your expectations are wrong, or they're padding their hours, but you got to figure it out. but don't doctor the records. Don't suggest they should doctor the records. Let me see what else in terms of litigation. I'm getting a fair amount of lawsuits now of, this is an interesting one. So the rule is that you're not allowed to fire an employee in California or take any kind of adverse action against their employment for reporting unlawful activity, either to a superior who can do something about it or certainly to some government official. I'm seeing claims now by on-site managers that they were terminated because they were reporting problems in the building, and those problems in the building, could be potential violations of habitability issues or some law. I think that's a creative claim they're making. And again, it's the kind of thing you want to address in your contract as best you can to button that up. There's a million other areas that I can go on this, and a lot of other things I can talk about. I'm just going to cover one more thing, and then I would suggest we open it up for questions. Because I neglected to mention this. On-site managers, the time they work is counted differently than almost every other employee. So when my secretary comes to work, let's assume she's got nothing to do the first 3 hours she's sitting there, but she clocks in at 9 o'clock and she sits there twiddling her thumbs till 12, then she takes her lunch break, then she comes back in the afternoon and she's got some work to do. Well, she's entitled to get paid for that entire time that she's sitting in the office. But an on-site manager is only entitled to get paid for when they are actually performing work. And you can see the reason for that, because typically they're at home and they can, they do take care of their own personal things when they're not engaged in actual work activities. So as long as they are on site, and they have to be on site, they don't get paid for their waiting time, they don't get paid for hanging around, they just get paid for performing actual activities. It's something that a lot of the lawyers don't seem to understand and recognize, and they file lawsuits that clearly don't understand this principle. But it's important that you understand it, so that, again, when you're figuring out how much time to allot to your managers and how long the job really takes, you can kind of figure it out using the appropriate rule. So again, there's a lot more to be said, but I probably confused you enough, so we can open it up to questions.
All right. Well, thank you so much. Thank you so much for sharing with us. And yeah, there's a lot there. I'm glad there's that article that you wrote, because it has all the numbers specifically in it. And if I understand, we have that article even in the more section, or pinned in the chat, maybe. Is that right? Pinned in the chat. So you can reference that article for yourselves. And we'll go to questions. We have Olga on YouTube. If I buy an apartment and existing on-site manager doesn't have any written agreement but has apartment for free, how can I discontinue their employment?
So Olga, let me address the second part of the question. I think the first part, I'm not sure I would require more information, and I'm not sure it's necessarily all that important to answer the question. So an on-site manager, like most employees in California, they're going to be what's considered an at-will employee. An at-will employee means that they can quit for any reason, and you can terminate that employment relationship for any reason. The one thing you can't do is terminate it for an unlawful reason. You can't discriminate it. You can't terminate it because you don't like their national origin or their race or their sexual orientation. But for any neutral reason, you can terminate them. So the first part, in terms of what the prior arrangement was, it doesn't really bear on whether or not you can terminate. And I will say, as a practical matter, if you just took over the building and for any reason you don't want to keep that manager on, now's the time to do it, because you have no baggage that he or a lawyer could point to and say you terminated him for some unlawful reason. You have the right to fire him. I mean, that's the way it works.
Great. All right, and Kong on YouTube. Does a rent credit require wage stubs if the resident manager works less than the credit amount in a month?
So that's a good, I'm glad you asked that question. It's an important question. So you remember I said earlier in the presentation that even if you're paying with a rent credit, don't say you're not paying, because you are. And so by law, any employee in California is supposed to get wage stubs, supposed to get paid at least twice a month, and they're supposed to get a wage statement or a wage stub with that payment. And that applies, if I'm understanding your question right, that applies even if you are paying them with a rent credit, and regardless of the amount of the rent credit, because you're paying them for their hours. And if they're worked an hour in the month, maybe you're only using $15 of the 900 you could on your rent credit, but you are paying them for that hour. And so that should be reflected in a pay stub. Worked 1 hour, rate of pay 15. Obviously, that's not minimum wage, so let's assume 16. And paid through a rent credit. That would and should appear on a wage statement.
Great. All right, Dolores, can managers make more than minimum wage?
Yeah, I'm sure they'd be very happy if you want to pay more than minimum wage. Minimum wage is just the minimum.
Right.
You can't pay less, but of course you can pay more.
Great. Okay. Let's see. Michelle. What is the best way to pay an on-site person whose duty is to only collect rent in the beginning of the month?
So that is, again, a question that I would need. It's going to depend. There are too many factors that go into answering that based on what you've given me. I can just say as a general rule, if you have an on-site manager who's working very little and therefore earning not very much in the month, and you have an apartment of any real value, then typically a check exchange would be the better way to pay in terms of your coming out ahead. Again, so you're not eating so much rent for someone who's really not working very much for you.
All right. And then Fu, please repeat rent credit for couple manager.
All right. That's the one I don't have in my head yet. So for a couple, it is $1,336.65.
Okay. And then Kong again. Do you have to withhold taxes such as unemployment, Medicare, Social Security when doing a check exchange?
So yeah, a check exchange is like paying any other employee, and you're paying wages and all the normal withholdings that you would need. You would have.
All right, Pam. The owner is having trouble trying to figure out how to tax me on a rent credit. Who can help his accountant?
Who can help his accountant? Well, I'm not a tax lawyer. I will preface my answer by saying this. I am somewhat familiar with the rules and how to do this. So I or someone like me could probably guide the accountant. There are some nuances, especially within the state in terms of the state, and how to handle some of the withholdings. So I guess that's the answer. I can help, but there are probably other people who can help as well if they know this area.
Right. Okay. All right. Hey, well, thank you. That's all the questions we have. If you have another question, now is the moment to put that question in before we close it out. And Gary, thank you so much. Again, Parker Milliken, I didn't say it, but it's a company that's been established for over 100 years. And anyway, so Gary is there and he's ready to help you. And you can see that this is his wheelhouse. And do you have any parting words for us, Gary?
Yeah, what I would say really in closing, every situation that you're dealing with is going to be a little bit different. And it's kind of when you're dealing with on-site managers, typically what I find is you're dealing on the one hand with all this legal stuff that we've been talking about. And then on the other hand, you're managing personalities, and no different than any other workplace, but in some ways, like I said, a lot more sensitive. And also because you're dealing not just with an employee, but also someone who lives on site at the building. And so you're kind of managing these things. And one of the questions reminded me of, the first question about terminating someone, can they terminate? So often there's the legal answer, can I terminate? And then there's the kind of more nuanced practical answer, which is, okay, what should I do? What's the best course? How can I best stay out of trouble? And the legal answer and the best answer are not always the same. Obviously, what you want to do, you have to make sure it's legal. But So, I would suggest if you have any questions, if you have an area, if you have suddenly discovered, as happens to a lot of people, that you've not been complying, and now you feel like you want to comply, talk to someone who can guide you through how best to approach it, because what you don't want to do through your now zealousness to comply is create more problems than you're solving by beginning to comply. This is a complicated area. Like I said, it's ripe for litigation, unfortunately, and there are a lot of hoops to jump through. So don't. I know this sounds self-serving when I say it, but don't try to navigate it yourself unless you have the background to do it, because there are a lot of moving parts, and it's easy to fall kind of into a hole.
Great. Yeah. Thank you so much. There are a couple more questions here. Now they're coming in. Okay. So on YouTube, Kong again. What if your resident manager is undocumented? Can you still do rent credit?
That's a tough question to answer, because if your resident manager is undocumented, you can't employ them. So, yeah. That's the short answer.
So they have to register for a tax ID.
Yeah.
And that kind of is difficult, right?
And I've dealt multiple times with situations where, after the fact, it's turned out that the on-site manager who's making the claim was not documented, and it's very sticky. But walking into it up front, the answer is don't employ them unless they're legally employable.
Right. All right, and then Michael. Regardless of any agreement I have from an attorney, I'm still getting sued, and it becomes a matter of attorney expense that is the most consuming. How do I avoid that?
Michael, it's hard for me to tell which part you want to avoid. Obviously, you want to avoid getting sued.
Yeah.
But if you're already being sued, you're right, and that's why. And you raise a good point, and it's one I probably should have made. These you don't want to get sued, and you want to bend over backwards to not get sued. I know that's not much consolation to you if you've already been sued, because these lawsuits are expensive, and because, as I said before, these laws are so hard to follow. They're very hard for the defense side, which is me typically, to outright win them. There's usually something there that is winnable, some technical violation, if nothing else, that's winnable by the plaintiff. Or even when I'll give you an example. Even when I've got really good time records of what the manager worked, and then that manager comes in and says, but no, I really worked more hours. So, but somewhere else hanging out there's some technical violation that I may lose on. I can fight, and maybe I can ultimately prove that the manager didn't really work the hours they're now not claiming. But unfortunately, I'm going to end up costing my client more money trying to fight that. And so I save 20 hours a month, but he spent that in attorney's fees to save those 20 hours. So it really is, in a sense, a no-win situation once you've been sued, unless you clearly are right and you're going to win the lawsuit. And even then, you still end up having to pay your own lawyer. So I don't have a great answer for you if you've already been sued. Obviously, I would assume you want to explore what it's going to take to get rid of the lawsuit, or if you want to fight it, but there's an expense there.
All right, Don, on YouTube, I have 2 9-unit buildings, both separately titled. Am I required to have an on-site manager?
So my answer is that it's not 100% clear in the law. My own view is that you do not. The reason I say it's not clear is that rule is not expressly addressed. By analogy, it's kind of addressed in the state regulation. So my own personal view would be no. But like I said, that's not so clear cut, and perhaps there are more facts I would need to know to answer that definitively.
All right, James. If I only have 16 units, do I have to have an on-site manager, or can I leave it vacant, the 16th unit?
I've never seen that question. I think that's a good question. My understanding and my assumption is that if you have a 16-unit building, you need a manager. But gosh, I don't know. I'd want to think about that one more.
Yeah. And it's such an arbitrary thing. Like, who came up with 16 units, right? Like,
I don't know.
and so that's arbitrary. One thing that's been kind of circulating is this, we oftentimes you hear the word mom and pop. And I'd like to kind of change that. All of you listening, most of you listening have 16 units or more, and you probably consider yourself mom and pop. And with the way the city councils work, they're really trying to help mom and pops. But I think we need to shift the argument so that we're all included, those who have 16 units, buildings or more. If we call ourselves private investors and distinguish ourselves from institutional investors, that might help, because I think what city councils are wanting to legislate against is more the institutional type investors, as opposed to you who just happen to own a building that's 16 units or more. And anyway, just a food for thought. And if we can start calling ourselves private investors and maybe not so much mom and pop, that might be helpful. And try to bring some understanding to our city council members. Might be good. Okay, Piero on YouTube. I'm a property manager and I'm supposed to work 7 hours a week, but I have to be on site from 8 to 5. What do I do?
So, Piero, I'm not sure what you mean that you're supposed to work 7 hours a week, but you have to be on site from 8 to 5. I'm going to read your question a certain way, and I don't know if this is what you meant. But I think you're asking about the part of what hours do you get credit for in terms of the work. And again, this is a unique situation to this type of work, to an on-site person, where just the fact that you have to be on site doesn't, assuming this is the building that you also live at and have to live at, doesn't necessarily entitle you to be paid for those hours, because they're not considered hours worked. So again, I know that you may not be free to leave, you have to be there, but the case law is pretty clear that just you're having to be there, again, assuming these other conditions, that you have to live there and you do live there, those are not necessarily considered hours worked unless you're working.
All right, Michael, what if I don't get a manager for over 16 units?
So that's a question I get a lot. And there are, the repercussions is, I believe, number one, you can be fined. Number two, I believe that it is potentially a misdemeanor. And number three, and what I have seen, I think more often than the other two, is where you will get some tenants complaining. And they will say they're not getting the amenities that they are legally entitled to, therefore their rent needs to be discounted. So those are the repercussions that I've seen.
All right. All right. Thank you again. Thank you so much for coming and making that preparation, coming down here to our office and doing this live with us. We really appreciate you. And you see his phone number and email, website. You see all of that. So give him a call. And anyway, we'll see you next time, and hopefully we'll see you guys next month in person at some of these meetings, some of these seminars that we have going on. Take care.
Thank you.